This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why no insurance policy covers every risk of loss and why a court will refuse to strain the language to find ambiguity that did not exist. In Erie Insurance Exchange versus Dragana Petrovic, a November 15, 2022 decision of the Court of Appeals of Illinois, the Circuit Court was found to have properly granted summary judgment in favor of the insurer, declaring it had no duty to indemnify or defend the insureds because the underlying accident occurred while the insured was operating his personal vehicle during the scope of employment, triggering the auto exclusion. Erie Insurance Exchange sued the defendants, seeking a declaration that Erie was not obligated to defend or indemnify its insureds in the underlying negligence claim brought by Petrovic. In that underlying negligence claim, Petrovic alleged a truck driven by the insureds hit her open car door as she was exiting her parked car and knocked her unconscious. Petrovic further alleged that they owned and operated the truck that struck her and that he was acting in the scope and course of his employment. Both the insureds were insureds under a commercial general liability policy with Erie at the time. Erie claimed, 1, the insured failed to provide it with proper notice of the accident, and 2, that coverage was barred under the auto exclusion provision of the insurance policy. After discovery, Petrovic and Erie filed cross motions for summary judgment, seeking a declaration regarding Erie's duty to defend its insureds. The Circuit Court granted judgment in favor of Erie and against Petrovic. Petrovic appealed, seeking reversal of the Circuit Court's order. With respect to the scope of coverage, the policy contains numerous exemptions, including relevant to the appeal. The auto exclusion provision, which states that the insurance does not apply to, quote, bodily injury or property damage arising out of the ownership, maintenance, use, or entrustment to others of any auto owned or operated by or rented or loaned to any insured, use includes operation and loading and unloading, close quote. In addition, the exclusion applies even if the claims against any insured allege negligence or other wrongdoing in the supervision, hiring, employment, training, or monitoring of others. The insurance policy further contained numerous conditions. Relevant to the appeal, the condition titled Duties in the Event of Occurrence requires the insured to notify Erie as soon as practicable of any occurrence or an offense which may result in a claim. Unfortunately, the insureds reported the accident 2 years after the accident, and Erie immediately filed a declaratory judgment action seeking a declaration that it was not required to defend or indemnify its insureds under the insurance policy. In reaching its decision, the trial court, and affirmed by the Court of Appeal, reasoned that to ascertain the meaning of the policy, the court must construe the policy as a whole as well as consider the risks undertaken, the subject matter that is insured, and the purpose of the entire contract. Where the words used in the policy, given their plain and ordinary meaning, are unambiguous, they must be applied as written. To determine whether an insurer has a duty to defend an action against the insured, a reviewing court must compare the allegations of the underlying complaint to the relevant portions of the insurance policy, and an insurer may refuse to defend when the underlying complaint, considered in light of the entire insurance policy, precludes the possibility of coverage. In this case, after reviewing the auto exclusion provision in the insurance policy and comparing it with the allegations in Petrovic's amended complaint and the pleadings and exhibits offered by the parties, The court found that Petrovic failed to state facts which either actually or potentially bring the case within the policy's coverage. Petrovic's amended complaint sought recovery for bodily injury and property damage arising out of the ownership and use of an auto owned and operated by an insured. Accordingly, comparing the plain language of the auto exclusion provision to Petrovic's amended complaint and the evidence offered by deposition of the insureds, there can be no dispute that the accident alleged in the underlying complaint arose from the use or operation of an auto owned and operated by an insured, so as to bar coverage and absolve Erie from defending the insureds in the underlying lawsuits. Petrovic made numerous judicial admissions that under the insurance policy, the insureds could always be an executive officer and an employee of the corporate insured. Since Petrovic's own admissions showed that the insureds were acting as an employee at the time of the accident, he was an insured. Under the policy, and the auto exclusion provision applies to bar coverage of the accident. By its plain and ordinary terms, the auto exclusion provision applies to any insured and therefore to both the executive officers and the employees of the corporate owner of the auto. Petrovic's interpretation of the insurance policy to the contrary would lead to an absurd result. Therefore, in the present case, Petrovic's interpretation of the policy language is neither reasonable nor supported by legal authority, and under those circumstances, the Court of Appeal refused to strain to find an ambiguity where none exists. In my opinion, the Illinois Court of Appeal acted as required and interpreted the CGL as written. Petrovic was seriously injured by Erie's insured, and if the coverage applied, would have responded with indemnity. I can only assume the auto insurer paid the limits of its policy. Erie was the target of Petrovic because she needed some way to gain damages for her serious injury. However, not everyone is insured for all risks faced by the person insured. No matter how deserving Ms. Petrovic was, no matter how serious her injury, the court could not create insurance coverage that did not exist, because no insurance policy covers every possible risk of loss. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you found this video to be interesting or useful to you, please subscribe to the blog and tell all your friends and colleagues about the blog so that they can also subscribe to the videos on YouTube and rumble.com. And if you watch this video on Rumble or YouTube, please click on the Rumble button or the like button on YouTube. Thank you for your attention, and also consider subscribing to my Substack publications and my locals community.